Our show it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property, Leo, okay? Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, our topic is Arizona's new partition law. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the channel, make sure to like and subscribe. You can find our channel on YouTube, Facebook, and X. And what we'd love for you to do is go and like and subscribe. It helps us out a ton. Also, if you could go to our audio version of the podcast, you can find that on Spotify. You can find that on Apple Podcasts. Go there, download an audio version of it. Helps us out a ton. We appreciate it. With that, I'm going to go to Sean, who has our legal update.
Thank you, Andy. My legal update today is, what is an affidavit of succession to real property and when is it used? So if you've been watching our show, you know that I've been doing basically a deed series. I've been talking about deeds, which are conveyance documents. It puts people onto title to real estate. Well, an affidavit of succession to real property isn't called a deed, but it is a conveyance document. It's a document that puts heirs on title to real property where there's the prior owner has been is deceased. So in order to do an affidavit of succession, a few things have to be met. So first, the owner must have been deceased for over 6 months. So there's a waiting period. And the reason for that waiting period is you want to make sure that creditors, other people who may have a claim with respect to the property or the estate, have a 6-month period to come out of the woodwork and to make those claims known. Then the second requirement is that the value of the decedent's interest in the property, and not just value, but the equity, decedent's equity in the property must exceed, or not exceed, may not exceed $100,000. So as long as the equity in the property is less than 100. So a few things to discuss there. So first, if let's say the property is owned free and clear, it's worth $150,000 and it's owned by two individuals as tenants in common. One of the individuals dies. Well, their interest can be conveyed by an affidavit of succession if all other criteria are met, because they only owned a 50% interest in the property. The property was worth 150, which means that their interest was only worth 75. Or let's say hypothetically that the property is worth 200,000 and it's owned by one individual. That individual dies, but there are liens, valid liens against the property of a total amount of 125,000, which once again leaves $75,000 in equity. Then again, that property can be conveyed by an affidavit of succession if all other requirements are met. So in order to do an affidavit of succession, you not only have to meet the requirements, but then the process for it is that it's prepared and all of the heirs entitled to their interest in the property must execute the affidavit of succession. Then it gets filed with the probate court, and the probate registrar reviews the affidavit of succession to make sure that all requirements have been met. And then they will stamp it as being filed. And then from there, you obtain a certified copy of the court record, and you take the certified court record of the affidavit of succession to real property and you record it with the county recorder's office. And then by doing that, you remove the deceased owner from the title and you place the rightful heirs onto title to the property. So an affidavit of succession is a conveyance document used to convey certain pieces of real property from a decedent owner to its heirs.
All right. Thank you, Sean. With that, a couple of reminders. Join us today at 3 p.m. Arizona time for the Creative Finance Collective. We'll be getting together with other professionals, attorneys in the space of creative finance. And we get together with attorneys from the states of Arizona, California, Texas, Ohio, Alabama, Georgia. We've had them from all over the place. But at the end of the day, there's kind of a niche group of lawyers that focus on the topic of structuring a creative finance transaction. So if you have questions about what that might look like or problems that you've run into and want to hear how lawyers might approach that from different areas or jurisdictions, this is the time for you. This is the time to come ask questions. We're the Creative Finance Collective goes for an hour, and we're on as long as we're receiving questions. So make sure to join us 3 p.m. Arizona time. Adjust your times accordingly, depending on what time zone you're in, but it'll be 3 p.m. Arizona time. You can find that on YouTube, X, and Facebook. So we look forward to seeing you there. Also, if you have, so we're going to get into our topic today, rather. Today we're talking about partition law. Now, we've spoken about Arizona partitions or partition actions in general here or in other states, but we wanted to focus today again on the topic because Arizona has a new partition law. And with us to discuss that matter and that topic is attorney Brian Locker. Brian, thanks so much for joining us.
Thanks for having me on, guys.
Yeah, so for our guests that are unfamiliar with you or have not heard from you before, why don't you give us a little bit of your background, how you got into doing what you do, and what your current practice focuses on?
Yeah, so I'm one of the partners at Fowler St. Clair, and my practice focuses almost exclusively on representing real estate investors in real estate litigation. And so the reason why I'm here today is because one of the things that we handle all the time are partition actions. And so I'm licensed to practice in both Arizona and Georgia. And I live in Georgia, but spend quite a bit of time in Arizona as well. And so I can represent investors in both states. But I mean, for the purposes of our conversation here today, obviously, what we're talking about is going to apply mainly to Arizona. Although strategies, I'm sure will sort of apply across the board, no matter where you're at.
All right. So as we dive into this topic, it probably behooves us to define a few terms, lay the groundwork for what it is that we're talking about. So just kind of more broadly speaking, from your perspective as a real estate attorney, what do we mean by a partition action? What are we even talking about?
Yeah. So when we say partition action, what we're referring to is the process by which two or more people who own a property together are seeking to divide that interest and separate that interest. And that can take place a number of different ways, but at its most basic level, that's what we're talking about.
And to have a kind of a concept for or further idea of what this is, why would somebody want to do that? I mean, what are the circumstances where people would run into situations where they'd want to or need to file something like that?
Yeah, I mean, so many times you choose to purchase property with other people, right? So I own my house with my wife. And so when we bought the property, we did that together, making that decision. Well, that's not always how you come to own property, right? People who have family members that own property who pass away will pass that property on to family members, some of whom may or may not get along. And so just in terms of why I see these actions most frequently, it's because someone has come into ownership of property or who own property for some period of time, and new owners have come in by virtue of someone passing away or that sort of a thing. And for one reason or another, do not want to continue to own that property with that other person or persons.
I've also seen it, and I'm curious your thoughts or how messy you think it is, but where non-married couples, so, maybe they were engaged, maybe they were boyfriend, girlfriend, or significant others, and they buy it together and they live in it together, and then the relationship kind of falls apart. Describe kind of those circumstances?
Yeah, I mean, I just got out of litigation that went on for well over a year in that exact circumstance where, I call it playing house, right? Because when you're married, there is a court process by which married couples can divide these assets. Well, when you're not married, that process is not available to you. It's called divorce, right? And so you have to seek these civil remedies, and then in this case, partition, to have these co-owned assets divided, and it really becomes sort of like a mini divorce action, right? Because the real estate is often and almost always the most valuable asset that these two people own, and so it becomes, I become almost like a family law attorney for the purposes of this action. And so, yeah, we see that all the time. I've got another case going on right now between mom and daughter and son-in-law, where they were living in the property together, and there was a family dispute, and they need to break up and sell the property. And it's sad when it happens, but these, this is the process by which it can happen.
What about with regard to like business disputes where partners have gone on as, joint owners of a property? Do you see it in that context?
I haven't really seen it in that context as much. I mean, I think, our firm represents a lot of small and medium-sized businesses, and often if you're going to have ownership of property in a small or medium-sized business, it's probably going to be owned under like one LLC as opposed to owned between, personally between two partners. So I don't really see that a lot, but the process would be the same even in that context, in the commercial context.
What about the situation? I would imagine that this is much more rare to see, but where a lien holder or a creditor forecloses on just the interest of one property owner, right? That could conceivably happen. And then all of a sudden a creditor is now a co-owner with the person that they didn't have a lien on the interest with. Have you seen that ever play out?
I personally haven't seen that play out. And I think the reason why I haven't seen that play out is probably because before that foreclosure of interest happens by the other party, there's probably going to be something that happens there that resolves that, whether there's a buyout by one partner with the other, he brings that mortgage current, and, and there's something that gets worked out there. But I'm sure it happens.
So
go ahead.
So once you have situations where you have multiple owners of the properties multiple owners of a property, and one owner's like, I don't want to own this anymore, what are the next steps?
Well, up until September 14th of this year in Arizona, it was pretty straightforward. You would file a civil action in the county where the property is located, requesting that the property be partitioned, and the court would go one of two routes. Route number one is if the property can be physically divided. So if we're talking vacant land, that sort of a thing, then there's a whole process by which the property can be physically partitioned, and you will end up with a portion of what was a larger property based on the percentage ownership that you have. Option number two, in the case of like a single family residence where you can't physically partition that property, then there would be a sale. And that was basically it. Those were your options up until, and it was a fairly straightforward process up until September. Less than 60 days ago, where Arizona adopted the uniform heirs property. Hold on, I want to make sure I don't get this wrong. The Uniform Partition of Heirs Property Act, which creates a much more complex process that gives people who have inherited property in one way or another an opportunity to keep that property where previously it would be much more likely that the property would sell.
Whenever we talk about lawsuits, we normally talk about defenses. And frankly, in my 15 years of practicing litigation, I rarely saw a case where there wasn't at least a colorable defense, something that could be alleged. What about partition actions? What defenses are available in a partition action?
Well, the one thing that doesn't exist is the option to force the person who's seeking to divest their interest to actually keep their interest, right? So in property law, one of the most important rights that you have in owning property is the right to divest yourself of that property. You can't be forced to hold on to property. And so we think that the most common way to do that is to sell, but that's not necessarily always the case. But that is a fundamental property right in the United States, is the ability to. So getting back to your question of defenses is if you are bringing an action, so you're the one, in this case, if I own property with someone else and I want to sell the property and you're the defendant. So we're saying, okay, what is the defense to this action? How can I defend this action? Well, previously to this new act going into effect, your only defense is the property going to be partitioned or sold? There is no defense to that. It's going to happen. By operation of law, you have no defense to that. The question will be, are there other things that need to be addressed by the court as part of that process? So the defenses don't become, hey, you can't sell this property. Although, I guess if your defense is this person doesn't actually own the property, there's your defense, right? But assuming for a moment that there is co-ownership there, then your defenses really become, okay, well, yes, on the deed it says that we own the property 50-50, but I have reason to believe, based on facts and circumstances, that the ownership isn't actually 50-50 because I invested a lot of money into the property that increased its value, or there was a mortgage that we were both on and I paid the mortgage for the last 10 years, or there might be a number of different monetary issues that need to be resolved that sort of become the defenses and is what ultimately gets litigated in the case. Not whether it gets sold, but how are we going to apportion the proceeds after it is.
Yeah, so you basically have the ability to figure out who gets what percentage of the sales proceeds or what amount of the sales proceeds based upon who maybe has put in for certain repairs, improvements, that type of thing. What if, and I know you see this because I've seen it a lot. What if one co-owner was residing in the property rent-free and the other one was not? How does the court generally deal with, basically rent-free use of the property during the term of ownership?
Yeah. So, obviously, anytime you have co-occupants, and one party moves out for a period of time, or maybe you had just had one occupant and the other owner wasn't occupying, right? This is going to be an issue that comes up in the case almost every single time. And at the end of the day, the way that this is generally handled is that the person who has not had the opportunity to occupy the premises makes the argument that they're entitled to 1/2 of the rental value of the property. Because again, we were talking about what sort of rights come along with property ownership. One of those rights is possession, the ability to actually use and enjoy that property. And so if that right has been taken away by one of the other co-owners, you can seek compensation from that owner who did have the right to possess that property during the ownership and say, hey, look, you owe me, half the value of the use of that property, and generally use rental value. So that can be an issue that comes up. There's defenses and things to that, like, you need to be able to show ouster. So could you have used it if you wanted to? Just because you didn't use it doesn't mean you couldn't have, that sort of a stuff. And those are the issues that come up there.
Now, in the traditional partition action, we'll jump into the heirs property in a minute, but in the traditional partition action, you go into court, you establish ownership, the court orders that the property be sold. What happens at that point? I mean, you get an order, it says, okay, properties to be sold, where does the case go from there?
Yeah, so judges handle it differently, and depending on whether you have represented parties or not. But let's just say that you've hired our office to help you do this process. So we have a motion that we file with the court to say, hey, judge, partition by sale is appropriate, and here's why under the statutes. And so we want you to order that the property be sold. And we have a form that we can use, like an order that sets out that a real estate agent gets appointed. We call them special commissioners that are appointed and empowered by the court to go and do all the things necessary to sell the property. And so in the case of, let's just say it's a single family residence, there's nothing particularly problematic about the property. So you could just list the property for sale on your MLS and find a conventional retail buyer, right? Then the court will just appoint any, you generally will have both parties submit names or whatever, but they'll pick a real estate agent, appoint this person, and have them list and sell the property. In the event that doesn't make sense under the circumstances, traditionally what we've done is we've asked for some kind of alternative form of sale. So like a blind bid type process or an auction or something like that. And the court can oversee that process to make sure that there isn't someone who's taking advantage or buying the property drastically below market value. And so the court in equity is going to try to arrange a process that makes the most sense under the circumstances, depending on what the property is, if it's going to go to a sale. I'm assuming for our discussion that physical partition of the property is not what we're doing here, because that's basically a whole different animal.
And at the end of the day, who pays for all of that? If the court's going to order it sold, a real estate commissioner comes in, they're not doing it for free, I'm sure. Escrow's got to close. That's not going to happen for free. Is that shared by the parties?
Generally, yes. So it'll generally be a portion based on the percentage ownership of the parties. So if you've got, 4 owners, each one holding 25%, the court's just going to split it all down the middle, 25%, or, evenly 25% to everybody from the proceeds that are deposited with the court.
Got it. All right. So we've kind of laid out the typical process for what it looks like to partition the property. The general idea is that the law is not going to force us to stay owners with those we don't want to stay owners with and affect the sale of the property. The landscape's changed a little bit here in 2024, and you mentioned it, the Uniform Partition of Heirs Property Act. Why don't you break that down for a little bit? What is the Uniform Partition of Heirs Property Act, and when does it go into effect?
Yeah, so at its basic level, so the existing laws didn't go away, right? They all still exist. And what this is doing is carving out a major exception to what we've been doing forever. And what it does is it says when you have what's called an heirs property. So if the property is considered an heirs property, then we have a new set of rules. And the purpose of this is to say, is to promote ownership of property within a family and giving an opportunity for family to keep a property in the family. So if you have a family home or a family farm or whatever you might have, right? The state of Arizona wants to give an opportunity to family members to keep that property. And so that's what it does. So to break that down just a little bit further, so an heirs property is very specifically defined in the statute. And what it basically says is any property that's held in co-tenancy between multiple people that also satisfies a number of different facts. So one is there's no agreement between all the people who own the property that you're going to just sell it. So if everybody agrees that, at some point, hey, we're all just going to sell this property and divide up the proceeds, you're allowed to contract your way out of all of these procedures that we're about to talk about. So assuming there's nothing like that in place, then it next asks, are there one or more co-tenants who have acquired the property from a relative, whether living or deceased. And so it's asking now, okay, of the people who currently own the property, how did they get it? Did they get it from one of their relatives? And then we don't have to get into this here, but relative is also defined, but it's pretty broad. Relative is pretty broad. It could be a number of different, it doesn't have to be your mom or dad. It doesn't have to be a brother or sister. It can be, you know, a number of different ways that you acquire that property from someone that you're related to. And then, so assuming that's the case, so it doesn't have to be everybody, but one of those owners acquired the property from a relative. Then the law looks and says, okay, if you've got that, then we're looking for one more thing. Either 20% or more of the interests are held by co-tenants. So if that person who inherited it only owns like 5% or something, then these laws aren't going to apply. So it's got to, you know, at least 20% of the ownership has to come from this, you know, inheritance type conveyance, or 20% or more of the interests are held by an individual who acquired title from a relative, whether living or deceased. So you can have either co-ownership between current owners or 20% interest that was inherited. It can be either of those things, or 20% or more of the co-tenants are existing relatives. So those are the things that the court is going to be looking for to determine whether this property is heirs property. Assuming you meet all of those things, and I will tell you as a practical matter, it's going to apply to a lot of cases, especially those people who are real estate investors who have employed this strategy of acquiring interest from people who have inherited property. It's going to apply in basically all of those cases.
Yeah. So if I hear what you're saying, if say 6 siblings inherit property, actually 5 siblings, let's say 5 siblings inherit property, and the real estate investor goes and buys 4 of the 5 interests because the 5th doesn't want to sell. In that case, the real estate investor can't say, well, I didn't inherit the property, so I'm good to go. That 5th interest holder has the right to have the protections of this act.
That's right. That's right. That is the minimum. That 5th person holds the minimum amount of interest necessary to trigger this new set of laws. Yep.
Now, I wonder if you could, maybe too early, or maybe it's too early to know this. This might be like a court type thing to determine, or maybe the statute addresses it. I don't know. But could you have a scenario where you had, let's say, more than 5 beneficiaries, 6 siblings, like Sean said, or 7, where the interest is less than 20%, but through the acquisition of some of the interest between some of the siblings, it then jumps over 20%. Can you then start out with the statute not applying, but now applying because more than was acquired? Does that make sense, what I'm saying?
Yeah, I mean, it's specifically contemplated by the statute, actually. So one of those 3 things, those last 3 things, one of them is 20% or more of the interests that are held by co-tenants are relatives. So as long as you have a cumulative amount of interest over 20% held by relatives,
okay,
it's going to trigger the statute.
Okay. So even if you had multiple siblings that make smaller fractional percentages, because that's all owned by relatives, they consider that 100% owned by relatives, right?
Until the 4 of the 5 are bought out by the investor, but even then, you still have the 20%. So to change the hypothetical to call out where we would not apply the statute, right? Let's say it's not 5 relatives, not 5 siblings, but it's 6. So now we have 6 siblings, and the investor buys out 5 of the 6. Now we have a situation where we have less than 20% of the ownership interest is held by a relative or who inherited it from a relative. And so now the law draws the line at 20%. Once you dip below 20%, that deals with the fact that you acquired the property it isn't enough. We're going to sort of expedite the process of liquidating this interest, and the home will just be sold.
If you're an investor out there, and I talked about this, in fact, in the legal update, one conveyance instrument is an affidavit of succession. But if you're an investor out there and you're looking at property and you're trying to make a determination of, hey, is this going to be heirs property? What are some conveyance instruments you'd be looking at to say, oh, I better look into this?
Yeah, I mean, anytime you're dealing with a probate, and the investors that do this know, right, that you're working with an heir to get them appointed as a personal representative, or to get them with someone to prepare an affidavit of succession to real property, or I mean these scenarios, it's going to immediately click with these investors. Oh, okay. And what they need to start thinking about is, do I need to plan for a longer process? Because this is sort of if you take anything away from our discussion here about the way that the law has changed in Arizona with regard to this process, is plan for it to take longer. And once you've got co-ownership between, and it doesn't have to be, that someone died. I mean, I had a case where it was just held by a mom and a stepson, and nobody had died in the recently, but even in that case, I mean, 20%. It's rare that people own less than 20% of a property, right? I mean, it does not happen very often. You typically have 2, 3, maybe 4 people who own property, but and so you got to start thinking, you got to start assuming that this new set of laws is going to apply if you're an investor and you're going in and talking to people about acquiring less than 100% interest.
So let's just talk about some differences now. So you mentioned a longer time frame. So starting at the beginning, take us through the partition process if the property is determined to be heirs property.
Yeah. So the first thing is notice changes. So before, we would just go and serve a lawsuit for partition the way you'd serve any other civil lawsuit. Well, now the court is very likely going to require that you actually post a sign at the property. Because often in these kinds of cases, the person who's the holdout, the person who wants to keep the interest, is the person who's living at the property. And I found that to be true. And so they're actually going to say that you need to basically post a sign. And the statute doesn't say the kind of sign, but I picture something resembling, a real estate agent's for sale sign. I mean, honest, something like that, right? I mean, like a stake in the ground with a big sign that says this property is subject to partition, and here's the case number, and here's the judge, and here's the description of the property. I mean, so first and foremost, there's a lot more notice that's likely going to be required. Now there's exceptions to that, and it doesn't necessarily happen in every case, but I would assume going forward, the court's going to want to see that kind of notice as judges start getting educated on this new act.
So the statute goes out of its way to use the term sign.
Yes.
Okay.
It says plaintiff shall post and maintain, while the action is pending, a conspicuous sign on the property.
What I think is really interesting about that is, on one hand, you could look at that and think, okay, well, they just weren't being very, maybe they weren't being very careful in their language. Although in statutes, at least in Arizona, they're usually pretty careful to craft the language when they want you to publish notice at the location, what that looks like. And they never use the term sign, right? This is like the first time I'm hearing like a sign. We've done tons of real estate cases where you have to publish a notice and send a process server to publish notice at the location. But
we call it nail and mail.
Yeah.
Right? You stick the thing on the front door, then that's enough.
Yeah. So, but never is there ever been used this idea of a sign. And that seems pretty intentional. I mean, the legislative drafting of that and using that seems, to your point before, like, do we have to actually craft a sign that goes there? I think that's really interesting.
Yeah, for sure. Another thing that happens right off the bat once this action is and you have service and you start moving forward in the case, is one of the very first things that the court is tasked with doing is determining fair market value of the property. What is the current fair market value of this property? That is not the way it's done in it traditionally. And so the court really is saying, all right, we got to figure out, what is this asset worth today? And it said, and so it basically says, go get an appraisal, like right away. We need to figure out what is the value of this asset.
And I've reviewed the statute, and maybe this is going to develop over time, like we talked about who pays the commissioner and the escrow agent. But I couldn't find anywhere in the statute to state who pays this appraiser that the court's going to appoint to submit an appraisal stating their opinion of value.
Yeah, it does address cost in the sense that I agree, it doesn't specifically say, but what it does say is what the court can do is, if the cost of the appraisal is such where it doesn't make sense. Let's say we have a very low value property, right? And even an $800 appraisal doesn't make sense under the circumstances. Then a court can opt to avoid the appraisal, and instead, I love what it says though, but it's still going to have a hearing, right? So everybody's going to have to show up, and if there's a lawyer involved, like, all right, well now you just drastically exceeded the cost of an appraisal. So I'm not sure. I guess when you have unrepresented parties, maybe that's the preference, is you're just trying to get rid of this thing. But it does address that. It also says that whoever actually pays for the appraisal, it can be assessed as a cost, as a taxable cost at the end of the case. So I think as a practical matter, whoever ends up owning the property, and we'll talk about the process by which we determine who's going to own the property, but whoever ends up owning the property, my guess is will be assessed a pro rata share of that cost, because it specifically says it's a taxable cost, and whoever fronts it is entitled to interest on the amount they paid.
Oh, okay. So basically, and I didn't pick up on that, but I'm glad that you've identified that. So basically, probably the party that brings it will be inclined to pay it initially just to get the appraisal done and the case moving along, but then it'll accrue interest, and they could go back to the, if they prevail, or to the party that ends up buying it, or who's going to have funds paid from the sale, and say, hey, look, you have to pay half of this plus accrued interest or something like that.
Right.
That makes sense.
Yep.
So once we have the appraisal, what next?
So once we've got the appraisal, we move into what is sort of the meat and potatoes of this new law, which is what they call a co-tenant buyout process. So we've already, because we're dealing with these statutes, we've already determined that at least 20% of the interests are by people who have acquired this from a relative. There is a familial relationship either between the co-tenants or someone who inherited this property. And so this is the new sort of protection for those people. So after the determination of value, the court is going to issue a notice. And in this notice that gets sent out to everybody, it puts a 45-day waiting period in place where any co-owner, except for the person who is trying to get the property sold. So if you're the one who says, I want to sell the property, you're excluded from this. You don't get to actually sort of reverse it and buy out everybody else. You're divesting your interest. You're not going to be able to get the whole property, which is an interesting check on abuse of this statute, actually. But any co-owner who didn't originally file this action has 45 days to acquire or to file a notice with the court to say, I want to acquire the person who's trying to sell their interest. I want to acquire it for the relative value, because remember, we already have an appraisal at this point that says what the property's worth. So if an investor, for instance, has come in and purchased 50%, and you've got the other 50% holder that wants to acquire it, let's say, using round numbers so it's easy, we have a $100,000 property. So the person who's trying to sell the interest, their interest is worth $50,000. The court's going to put out notice, and that other 50% interest holder has 45 days to say, I will pay the $50,000 to acquire the other interest. They don't actually have to put up the money yet. They just have to tell the court, I want it. And so at this point, we're just waiting for 45 days to see if any of the other interest holders want that interest at the price set by the court at fair market value. So we wait the 45 days. After that happens, the court will say, okay, did we have an election? Did someone decide that they want the property? And if we have at least one person who said, yes, I want that, then the court will then allow at least 90 days for that person to come up with the money. So you can start seeing, when we were talking about plan for extra time here, right? We've already had to go through service and notice, and now another 90 days. So again, just as someone who deals with these a lot, just to put some context on how much time we're talking about here, getting to the point where the court puts out the 45-day notice, we're probably 4 months in at this point.
Right. Yeah.
Right. And so we're talking 45 days plus 90. So we're talking about 4.5 more months. So we're now at 9 months once the 45 days runs, and assuming that this person has elected to acquire the property. Never mind that in my practical experience, the people who want the property can't afford it.
Well, that was going to be my next question. If you're going to make the election, do they at least require a showing that you can follow through on the election?
You better believe we're going to ask for it. Because I've got a case right now where this guy has been living in his home. It was his family home. He grew up in the house. His dad died, left him the property, and we can't, my client came to acquire 50% ownership. Look, I feel for the guy. Like, he wants to stay in his childhood home and wants to acquire the home, but the reality is he doesn't have the money. But under this scenario, he hypothetically can buy himself at least 9 months, because what this statute says is it has to be at least 90 days, meaning that is the absolute bare minimum the court is allowed to give before it closes that window on acquisition. I can contemplate if that person knows what they're doing and reads the statute, that court will likely give far more than that. I mean, if you got someone who's saying, "Oh my goodness, this is my childhood home. You can't take this away from me. This is a big bad investor that's trying to come in and just take it, rip it out from I live here." I could absolutely see a scenario where a court's going to say, "I'm going to give you 6 months," and there is nothing the investor can do without some sort of maybe we have some reason to believe that they can't possibly afford the home, or they can't qualify for a loan or whatever. I would not plan on being able to get that, though. And we won't know, right? I mean, all of this is untested. This law went into effect less than 60 days ago. So I've had none of my existing partition actions that are in the office have come in that 60 days. If it's not even 60 days. They're all existing prior to the enactment of this legislation. So we just got to see what a court's going to do here. But in my experience, the court's always going to give the benefit of the doubt to the person who inherited that property.
Jumping back just for a moment, because I feel like we moved forward, and this was my fault because I assumed a couple things, but I think we assumed the process. We assumed the process of the appraisal would be whatever the appraisal says is an accepted amount. Does the other side have an opportunity to contest the value of the appraisal?
Yeah. I mean, we didn't cover that mainly because I don't think that'll be the outlier situation.
Yeah.
But yeah, absolutely. So once the court obtains, in most cases, obtains an appraisal, yeah, there's a party has 30 days to contest the appraisal and give reason why that appraisal is inaccurate. And you could totally see the scenario where this might happen, where you've got everybody assumes that these things are always like, single family residences and big planned communities where you can find comps all over the place to figure out what, have confidence on what that value is. You could absolutely see the scenario where this wasn't that kind of property and it was a one-off. Maybe it's vacant land somewhere. Maybe it's a cabin up in Payson, you know what I mean? Where your comps are going to be much more, potentially unreliable, where a property owner or, a co-tenant might say, wait a minute, this thing isn't worth 300 grand. It's worth 600 grand. And here's why. And a court will have a hearing about that to determine whether it should find that the value is different. Yeah.
So we get to the point where they've got 90 days to, after they've elected to buy the property, they have 90 days. Is that right?
Yep. 45 days to make the election, at least 90 days to come up with the money.
So in that 90 days, do the parties open escrow? How is this property conveyed eventually to the party electing to purchase it?
Well, so let's assume for a moment that the election is made and the money is properly deposited.
Yes.
Within the 90 days. So the court will enter a judgment declaring the interests of the parties, and that judgment will act as a warranty deed to the people who end up buying it. And that could be one party, it could be 2, 3, 4 parties. I mean, it doesn't limit it. There can be as many people trying to sell their interest and as many people trying to acquire the interest as there can be owners of property. So there is no limitation.
So in our practices, the three of us are always dealing with title companies, title issues, things where title gets screwed up. And one area that title gets screwed up is, and not so much in partition, but in divorce proceedings where the decree comes out and title companies look at the decree and say, yeah, this is not enough to convey title, even though the property was awarded to one spouse. And they're like, no, you got to go redo this, or you got to get the spouse to sign a warranty deed or whatever. Let's take our investor attorney hat off and put on our hat of, if you represented one of those heirs who are going to buy, the party seeking the partition, you're going to buy them out. What recommendations would you give to them to make sure that they're going to get what they're buying, which is good, clear, clean title, effective immediately upon order of that court?
Yeah, sure. So the statute's actually contemplated. I'm trying to remember whether it's in the original. Yeah. So one thing to keep in mind, remember, so we've got this new act for heirs property, but it does say that as long as there isn't something that is inconsistent between the existing partition statutes and the new partition statutes, the old partition statutes can also apply to the process, so long as they don't conflict. And so under A.R.S. 12, 12, 14, so those are under our old partition statutes, it says a court may order that an abstract of title be obtained with the cost afforded to the procuring party plus interest. So to answer your question, as someone who would be acquiring the interest in the property, that's where you got to go. You got to go and get an abstract of title to make sure the title that you're getting is good and clean and marketable. Because whatever the court does is going to qualify as a warranty deed. That doesn't mean you're still not going to have problems down the line of actually getting it sold. It's not bad, but you want to cover your bases for sure.
And assuming that the title company might cooperate, the title company that provides that abstract, would you be inclined to submit the proposed form of order to that title company and say, hey, would you secure or insure a subsequent conveyance based upon this order being entered?
100%. Yeah. I mean, that's easily worth the cost that a title company might charge you for that, right? A few $100s, depending on the value of the property, could be upwards of $1,000 or so. But yeah, absolutely. I would recommend doing that.
But doesn't some of this illustrate why the process might even be longer than you even think it's going to be? Because let's say you've got the election, right? I'm going to do it. Then we start digging in, and you start digging in, and then you find title problems, and you're like, oh, well, I guess I'm not getting exactly what I wanted. So it all comes apart at the end. Well, let's just go there. What happens if you make that election at the end of 90 days and it, you decide not to move forward? Is there an out at the end of 90 days? Does the court penalize you if you fail to finalize the sale? What does that look like?
There's nothing in the statute that would penalize you if you ultimately don't come up with. Now that won't stop people from maybe trying to get penalties. If someone was acting in bad faith and you had evidence that this person was needlessly trying to increase the cost or the duration of the litigation in bad faith. Yeah. I mean, the court's going to still have the ability to punish that person, but there's nothing built into the language of this particular act that does that. It just says either they come up with the money in the 90 days or they don't. And if they don't, then they don't get the property, or they don't get that additional interest in the property.
So it feels like the 90 days is like a earnest deposit free due diligence period, right? That's basically what it is.
I mean, there's nothing in the statute that gives you any strings to this elect. It is a risk-free election as far as I'm concerned, other than the parties who are sitting there waiting for this process to conclude. They might get upset and ask the court to do something about it. But I mean, in my experience, court's not going to generally be inclined to do that unless there's a history of this person doing that kind of thing.
So let's say the 45 days runs, they don't elect, which, like, to your point, they probably would elect regardless. But let's say they don't elect, or let's say they do elect, the 90 days comes and goes. They don't purchase it. It's determined that they either aren't or don't have the means or capacity to purchase. What next?
So at that point, the court, if it's clean, meaning we do have money that's been deposited or no election has taken place, so we can determine, hey, here are the interests that are going to be divided. The court is going to likely have a final hearing that says, here's what happened. Here's what's going to be the new interests of the property, and they're going to enter a judgment at the end of it. And so that's when it's clean.
Mm-hmm.
If it's not clean, I mean, that sort of takes us, and I don't know the extent we want to get into the weeds on this, but if there isn't a co-tenant buyout, or let's say that there is, because remember that all of this starts with one co-tenant wanting to divest their interest, right?
Mm-hmm.
So if at the end of this whole buyout process, part of that interest that's trying to be divested still remains, because here's a scenario where this could happen. So you've got 4 people, 25% interest to everybody, and 25% is owned by an investor. So the investor files the partition action, and the other 75%, 2 of them elect. And so presumably each one of those 2 who have elected are each going to get 12.5% of that 25.
Mm-hmm.
Well, let's say one of them comes up with the money, the other one does not. So now we've got this 12.5% that's still kind of just out there, right? So the court is going to say, okay, for the other person who elected, you were only on the hook to come up with the money for 12.5%. We'll give you additional time if you want to come up with the money for the additional 12.5. So now you'll get the full 25%. You'll be 50% owner of the property at the end of this. Do you want to do that? And if the answer is yes, then they'll get more time to come up with the money to get that. Probably not a full 90 days. I forget exactly how the statute defines it, but they'll get more time. If they say no, I only have the money for the 12.5%, or whatever. So we still have this 12.5% that's just kind of sitting out there that is unclaimed at this point. So now we go into partition in kind or partition by sale. These are the only two things that are left. And partition in kind is sort of like a modified physical partition, where the court is going to do everything in its power to find a way. And in my example, we have this 12.5%. Find a way to allow this 12.5% to be sold off without affecting the rights and the ownership of the other 87.5% interest. And there's a whole long, if you want to go look at it, A.R.S. 123607 talks about how the court, and 3608 talks about how the court is supposed to grapple and try to do this with an eye towards, we're trying to keep this property in the family if at all possible. But if that isn't possible, and there will be plenty of certain circumstances where that just won't be possible, then we go to a sale. And we finally, at the end of all of this process we've been talking about, you're probably a year in. Yeah. Realistically, you're a year in at this point. We're at a sale finally. And
without getting into the weeds, my understanding is the sale is a lot more supervised as far as what can be offered for price, purchase price, what can be listed on the MLS. Like the court's going to have its hand a lot more involved to make sure that they receive the highest and best value that they can for that property.
Yeah. The court is provided with wide latitude to make sure that there is fairness and equity in the process. Yeah. That's the bottom line.
Yeah.
All right. Well, really good information. Real quick, what advice would you give investors? I mean, prepare to wait.
Yeah. Well, look, the best circumstances in these cases is one where you're able to build a rapport with the other owners and work with them, come up with creative solutions. Maybe it's I guess I don't even want to get into examples necessarily, but find a way to work with the other owners, because that's going to be your fastest. Don't take hard money on these cases. Because even the way things are now, you're still usually looking at about 6 months to get a house on the market. This is going to at least double that,
right?
At least. And so don't lock yourself in to expensive money and hope you can recoup it on the back end. These cases, these deals are becoming more risky, I guess is the bottom line.
Yeah.
Well, that's really good information, Brian. Why don't you tell our listeners how they can find and connect with you?
Sure. You can find me at fowlerstclair.com, make an appointment to meet with me. Or you can call me directly, 480-562-6748. My email address, locker@fowlerstclair.com. Always happy to chat and see if you got something that we can help with.
All right. Thanks so much, Brian. We appreciate your time. Let's do it again soon.
All right. Sounds good. Thanks, guys.
All right. With that, everybody, that is our show. Make sure to join us this afternoon, and we'll see you next week.
Have a good day, everyone.